should be going in just a few seconds here. Sorry to hold you, Perry, but just take a minute here. Okay, we're all set. With that, I will hand off to Perry, and if you want to share your screen, and we can get started on this evening's presentation.
Great. All right. Thank you, Tom. Thank you, everyone. It's a pleasure to be here. As Tom mentioned, I am a lawyer. I have been practicing intellectual property law for more than 20 years, all of it here in Silicon Valley. And what I wanted to do tonight was to talk a little bit about, four, I think, of the primary types of intellectual property that are likely to come up and raise issues in the design, development, marketing, and sales of products, and may interfere or interact with the engineers and the employees at companies who are making those products. And the four are listed here. It's trade secrets, patents, trademarks, and copyrights. And then at the end, I want to spend a few minutes talking about lawyers, litigation, and sort of my views and my take on what are the best ways to work with lawyers. So hopefully, kind of go behind the curtain a little bit and see what are some of the better practices that I've seen in my years doing this in the ways people work with lawyers. So I'm going to start. We'll start right in. I actually want to start, though, with an interactive poll that we have, because a lot of times, you hear a lot about intellectual property. And I think one question that's often overlooked is, what is it worth? You hear people talk about the patents they have, or the trademarks that they have, or the copyrights. And it's always a question, what are they worth in dollars? And so I just wanted to start with a poll that I think Tom can put up. And, the question is, it's a little unfair because obviously the value of intellectual property depends on who the owner is, who the accused infringer is. But I have four examples up here where I ask, which of these do you think is the most valuable in dollars? And then as we go through the presentation, we'll use sort of each one of these as a talking point or something that we can use for the discussion. And so the first one are some LED lighting patents. They're asserted against a large lighting distributor. A trademark for a color used on tools, the color red used on tools. Then you have a copyright for software APIs incorporated into an internet browser. In APIs, they're just like a bit of code that's used sort of transitioning between aspects of a larger piece of code. And then finally, trade secrets. These are, secrets of a company that were allegedly misappropriated, and the secrets related to NAND flash memory. That's sort of an older technology related to, a lot of people think of it as thumb drives that we used to use a lot. And those are the three topics, and I'll go through those in more detail. But it looks like we have roughly, some people have weighed in on the poll. I don't know. It looks like we have a representative enough sample, Tom, do you think? Or do you want to?
Yeah, we're just getting a couple people in here. So get your votes in quickly, or
right.
We've got a couple more coming in here. All right, so we're going to cut it off in 5, 4, 3, 2, 1. Ending the poll.
Okay.
And we share the results out to everyone. And take a look. That's most people. Looks like they went for the LED lighting as the most valuable.
Right, and that's a good guess. With the information that I gave you, I think that is a safe guess, but it turns out that is not the most valuable. It actually, in my experience, and these are all real cases that we will talk about, it was actually the trade secrets covering marketing plans for NAND flash memory.
Wow.
Yeah, and so we'll go through that. And actually, why don't we just start right in here on um, trade secrets, and we can just get going on that. And I chose to start with trade secrets that because this is actually can be the scariest, the most serious, the most expensive type of trade secret dispute to get into. And it generally involves two types of situations. One, an employee moving from one company to another, and two, joint development. And so to just illustrate the basics of trade secrets, I'm just going to talk about a case that's been in the news recently, which has a very common fact pattern. I've handled, you know, I would say half a dozen cases in this scenario, and it is an employee of Google, a high-ranking engineer in what became Waymo, the self-driving car unit, left to form Otto, a self-driving car company that was subsequently acquired by Uber. And the allegations were that the engineer took with him trade secrets. He took with him code, emails, documents, plans of the company, all secret information of Google that allegedly was valuable because it wasn't known to Google's competitors. And the case went into the courts. Google got an injunction against Uber. And most, just what makes these cases hard is that there were serious penalties for the employee. He is actually facing criminal liability. There is criminal liability for trade secret misappropriation. That's really only in extreme cases, but it still exists. And so I raised this first just because this is a situation where a lot of people could potentially find themselves in, and that is you're working for one tech company, you go to another tech company, and you want to do basically the same thing. And so the question often arises, what can I do to be sure that I don't run afoul of my former employer and don't run afoul of the rules of the road? And so the place to start really is the rules. And in California, California is a unique state in that employees do have certain rights. One of which is that there is a law that says you cannot be held to a contract that would interfere with your ability to do your job. So it is illegal for an employer to attempt to restrict an employee from moving somewhere else to do their job. The other sort of employee beneficial piece of law in California is a court case that talks about something about inevitable disclosure. And that basically means if you're working somewhere and you go somewhere else, even if you don't take any documents with you, even if you just go there with no evil intent, companies can try to argue that just what's in your brain will inevitably disclose their trade secrets. And companies were using this to say, well, look, this guy was so enmeshed with our program, there's no way that he or she could do their job without using our trade secrets. And the courts in California have said inevitable disclosure as a doctrine is rejected. That's just another way of restricting employee mobility. So there's a foundation in California that protects employees, but employees still need to take steps to be sure that they don't themselves run afoul of trade secret law or their new company. And so where you can run afoul of it are with the agreements that you would sign with the company. And oftentimes, almost every time, there's a confidentiality agreement, usually an employment agreement, an invention assignment agreement. And what these usually say are obviously you have to keep everything that you learned from the company secret. You can't use it against them. Then your employment agreement says you're just going to work for your company. And the assignment agreement would say you have to assign any inventions you come up with to the company. And so normally with these contracts, the way to avoid exposure, the way to avoid getting into a problem are, first of all, to not bring anything with you, right? Don't download documents before you leave. Don't save a bunch of emails. Don't take code with you. And it's surprising because that seems so common sense, but in a lot of cases, maybe not that Google case, there's cases where people think, well, I wrote this material. I wrote this marketing plan. I based it on publicly available information. What's the big deal, right? And I just think anytime you're taking digital records with you, you really expose yourself. First of all, it really looks bad. And secondly, a lot of companies do have pretty sophisticated surveillance that they can run retroactively on an employee who left, and they can just see the records of what was downloaded with their computers. So that's the first thing. The second thing is to be sure, as you are planning your next venture, as you're recruiting people, do not do it on company time. Don't do it in the company offices. Don't use company computers to plan your next venture. A lot of us have a private email account and a work email account, and I think we all know that they tend to bleed over. And in these situations, it's key to keep it separate. And then the final point is on the assignment agreement. And assignment agreements are probably the least of your concerns, because as long as you're not taking any confidential information with you, you won't be having a trade secret issue. You may have filed a patent application with your prior employer, and you may infringe that patent when it finally issues, but you won't have a trade secret issue. So those are sort of the main points to bear in mind. I think the final thing I would say in this employee mobility situation is it's worthwhile to consult a lawyer, spend a couple $1,000s, and just, if you're going to a new venture, to talk to somebody and just be sure you're clear that what you're doing doesn't potentially run afoul of your prior employer. And I have to say, in my experience, surprisingly, these are emotionally charged cases for the company that the employee is leaving. I've been on the side where representing a large company suing somebody who left, an individual, and a large company, you kind of think, well, it's one employee of 20,000. Like, what's the big deal here? But you can't really discount the sense of betrayal where a star employee is leaving. So, given the severity of what can happen, I think the reason why I led with this sort of case is because this is one that can be avoided with relatively low sort of legal expense, and the potential downside is pretty great. So that's the employee mobility case. The other trade secret case is joint development, and this is where we get to the question from our poll. And what can happen is sometimes you'll have companies who are working together on some joint project, and they have a falling out. And this is actually a case that I worked on many years ago, and this was the winning answer. These trade secrets were the most valuable. They resulted in a jury verdict of over more than $300 million for the plaintiff. And what happened was, I don't know if anybody remembers Lexar. It was a local company that made these jump drives you can see on the right that basically package flash memory, NAND flash memory. And they had got an investment from Toshiba into their business, and Toshiba learned all of their secrets, how they were going to plan to market these chips, how they're going to market the NAND flash memory. And as the market evolved, Toshiba sort of realized that it made more sense to be supplying the whole market, including a competitor of Lexar's. And the allegation was that they basically dumped Lexar, took the trade secrets to somebody else, and left Lexar out of the cold. it went, to a jury trial in Santa Clara in the Superior Court. It was this huge verdict. And eventually, after this, I'm not sure anything was actually paid, because Lexar was eventually acquired by Micron, who had a relationship with Toshiba. But as a practical lesson, or sort of as a point for anybody who's involved in this, these joint development agreements need to be very carefully lawyered. In a startup, if you're receiving an investment from a larger player in the industry, you really need to think through the legal side of it, the marketing side of it, the operational side of it, and proceed very carefully. And if you're a large company as well, you need to really sort of balance these things out, because if you look at litigation, a lot arises from sort of a joint development agreement gone awry. And a lot of where the problems come from are where, there were secrets shared, which is sort of inevitable between the companies. So that's sort of an overview of trade secrets. It's actually a relatively simple concept, a relatively simple form of intellectual property. It's essentially a secret. But as I mentioned, it's sort of fraught with danger, more so than any of these other things that we're going to talk about, just because it involves employment, and it often involves large amounts of money. So I wanted to start with that. I would open it up to questions if there are any. If not, I'm more than ready to move on to our next category.
We did get one comment in saying, a couple thousand seems like a lot to spend when you're moving a job, but they were saying it sounded like it was money well spent to prevent worse things further down the road.
Right. Yeah, no, I agree. And I guess, and I wouldn't say that in every move, right? If you're moving from, large company A to large company B, and your role maybe isn't like the integral engineer or, like the main product manager, even, maybe it's not as serious, especially if you're moving from a company that is not starting a new business line, right? If you're not being recruited in to build a business line that competes with somebody else. But yeah, I think, anytime, and it may be that it's also a high enough level position that that the attorneys think makes sense. But yeah, it's definitely something to consider in that situation. So, all right. So that's trade secrets. Then moving on to something that I think is probably more near and dear to many people's hearts, and something that is I think more prevalently litigated, and those are patents. And I think, big picture, patents are probably the most commonly obtained and probably the most valuable. Despite what I just said about trade secrets, I think in terms of positive value for a company, patents are probably regarded as the asset that is most valuable if done right. And just a quick, rundown: a patent grants the owner of the patent a monopoly over the invention, which means they can demand a royalty payment for the use of the invention claimed in the patent, and in some cases even prevent people from using the invention through a court-ordered injunction. Patents are examined in the patent office. It is a rigorous examination. That's not to say invalid patents don't issue, but they are closely examined. And patents, while you can file with the World Intellectual Property Organization or the European Patent Office, in order to enforce a patent, generally speaking, you need to have a patent in the country where the infringement is happening. So To go after an infringer in the United States, you need a United States patent. To go after an infringer in Canada, you need a Canadian patent. And that's globally how it works. And all of the rules are different. Europe, the United States have probably the most similar systems. The systems are different in Asia, very different in India, different in China. And so oftentimes, if you're getting a US patent, but you expect infringement overseas, you would need an overseas patent. But you can always go after people who are importing the product into the US using a US patent. And I have a specific example about sort of the global flavor of that in a moment. But now I'd like to focus on this patent. And just to kind of go through the basics of a patent. So you see on the graphic that we have here, this is just the front page. And this is a patent for an animal toy. This is an actual real issued US patent. It issued 18 years ago. And I don't know the story of this, but this is a patent for an animal toy. And what you see is the abstract, the title, then they have a drawing. Your typical patent will contain a number of figures and a written description of the invention. And so here we have this, this stick, basically. The inventor went through, described all the features, made this drawing. I can't quite imagine what all these numbers are pointing out. I mean, it looks like a lot of bark, but in any event, this is the patent. And then you get to the claims. And the claims are the most important part of a patent because they define your invention. So if somebody makes a product that is described by these claims, then that product will infringe. So here we have an animal toy comprising a solid main section having a diameter and a length. Then part B, there's at least one protrusion attached thereto, extending a predetermined distance therefrom. Where it includes another longitudinal axis. And then finally, this animal toy is adapted to float on the water. And so that's a kind of standard way of claiming, but this patent I actually got from a list of kind of the silliest patents or crazy patents that it issued. And every year, the list comes out. And this basically describes, a stick. This is a stick. And so, you can see that every so often patents like this get through the patent office. And there are a number, and you'd be surprised that, IBM has had a number of patents that have come out that they've dedicated to the public because they were just silly. So most patents aren't like this. The problem with this patent is that it probably describes an obvious invention. And so for a patent to be valid, it needs to be new, non-obvious, and useful. And this patent, if challenged in court, would probably fail the obviousness challenge. So moving from an obvious patent, before I move on from this, I want to illustrate a point. So this is sort of an example of a patent that's probably invalid. But when you're working for a company or when you're in a startup and you're thinking about patenting, first of all, getting patents is very important for a company. It first of all helps people value a company. If you can point to patents, issued patents, and say, this is what, we own these patents that cover this product, it is a way of formalizing the invention. And it is a way of sort of proving up the value of a product and showing ownership. And oftentimes I find that in companies or in startups or even individuals who are working on product development, there's a reluctance to see that their invention is actually patentable. I think a lot of people, a lot of engineers would think, something, it's like getting a Nobel Prize. It's like a recognition that you really did do something that advanced your field. And that's really not the case. I had a case for a very large multinational corporation. They were in litigation with another large multinational corporation, and they had assembled a number of patents on both sides, and I flew out to meet the inventor on one of these patents, and it was sort of our lead patent. It was the focus of the case. This person was about to be deposed in this foreign country. She didn't speak English, so I flew out there, took the company helicopter to the research site, and I sat down with her. And usually when I first meet an inventor, I say, hey, so can you just explain to me, how did you come up with this invention? What's the story of the invention? And she said, well, I didn't invent it, and it's really not an invention. It really is nothing. It's not an invention. I'm sitting there thinking, oh, okay, great. Here we are. We've sort of staked or put all our eggs in this basket, and here's the person telling us that it's not really an invention. So I asked her, how did it come to be that your name is on this patent? And she says, well, my boss said that in order to get a promotion, I needed to get a patent. And she said, okay, fine. I'll do that. I'll get a patent. And she thought about it. She said, well, what should my patent be? And he said, well, just describe what you're working on. Just write down what you're working on, and that'll be good enough. And in her mind, that wasn't an invention. But, in the patent world, it absolutely was an invention. It was a unique feature on a cell phone that added value to the phone, was a novel way of doing something. And yeah, granted, it wasn't the invention of, the complex coding algorithms that can send the data over the antenna, but it was certainly a worthwhile invention for patent purposes. And so it's sort of a long way of saying that I guess it's important when you're in the product life cycle to always look at things that you believe differentiate your product in the market as also technological differentiation. And I urge people to think creatively when they're doing that. So the next 3 slides, or the next 3 things I want to talk about, are creative ways that people got patent claims, very valuable patent claims, by taking sort of what they were doing in patenting. And so the first one is, people have probably seen this before. This is an Amazon patent from years and years ago, and it's one-click ordering. And it is a business method. And I think people have heard a lot about business methods. In my mind, this is kind of one of the early business method patents that was really heavily litigated. And this was 15, 20 years ago now that this was litigated. And it covered this notion of being able to order something with one click. You click one button and there you go. And I think there are people who might have thought at the time, well, ordering with one click, like, is that really? And there were other people who realized that, yeah, that is a novel, useful way of ordering products. And so I chose this to illustrate sort of that point, but then also to talk about business method patents. Because, a question can arise, if I think of a unique way of doing business, can I get a patent for it? And the answer is yes. But it's not intended to cover business plans per se, right? I think a business plan is more like something you keep secret, and it is a trade secret, right? You want to keep your business plan secret. What a business method is a way of describing, oftentimes nowadays, it describes complex financial algorithms. And some of them are, some of them aren't, covered business methods. But a lot of times it would be, like a financial hedging algorithm. It would be like some kind of escrow, unique escrow algorithm. And the key is that in business methods, what is not allowable is basically saying, here's something like renting a car. Okay, you rent a car. In the olden days, you go up to the kiosk, you rent the car, you get the keys. And basically saying, I want to do a patent on renting a car over the internet, right? That's where business method patents are not allowed. It has to be something that's really new. So just saying, oh, a way of doing business on the internet or with a computer is not going to cut it. But there's more of these high-level software operations, like a new way of doing it, right? You couldn't ever really buy something with one click in the past. And there are other examples of sort of business methods. So this is an example of where this is a type of patent that you kind of need to think hard about, is it truly unique? Because what has happened is a lot of business methods have come out that are essentially computerizing known things. And there is, in fact, a procedure in the patent office to weed those out, covered business method patent invalidation proceedings. So again, there's sort of a long way of saying that think about business methods, but remember, they really have to be new and unique. And it can't just be something that's already been done, sort of put on the internet or otherwise, dressed up. Now, the next patent I would like to look at, this is just an example of an extremely valuable patent. This is a patent that's owned by Caltech. It was recently asserted against Apple, and it resulted in a $1 billion jury verdict here in the Northern District of California. And $1 billion is a gigantic jury verdict for a patent case. I think the largest jury verdict ever in the United States was $25 billion, and it was a horrible class action, I think, somewhere in Florida or Texas, and it was overturned. But $1 billion is on the outer edges of what is recoverable damages. And this is basically a Wi-Fi coding mechanism that was included in a Broadcom chip, and the Broadcom chips were included in every iPhone, every iPad, every Mac, every Apple product out there. And so the damages were just enormous. And this is it's a very well prosecuted patent. It was owned by Caltech. And the reason why I wanted to focus on this is to start talking about the notion of non-practicing entities or patent trolls. Because other than this being a very valuable patent, Caltech is a university that is arguably not a practicing entity. They're not selling a product that uses the patented invention. And we throw around the term patent troll a lot. And most people who have been sued by somebody for patent infringement feel like the other side's a troll, right? And classically, the definition of a patent troll is somebody who buys a patent and then goes around and sues a bunch of people. That's your classic patent troll. But that's evolved recently to include entities that own patents but don't make and sell any products. That could include individual inventors or things like that. And so what that highlights is the patent law has really been, I think patent lawyers, the patent bar, Congress, have been really trying to get at the problem of patent trolls. But in some ways, it defies definition a little bit. Because if you go for the non-practicing entity, then maybe you get the university that spends billions of dollars bringing like really useful inventions to light. Or you get the failed pharmaceutical company that may have had a good drug, but just didn't have the wherewithal to get it to market. And so in terms of dealing with patent trolls, there have been some changes in the law in the last 10 years that have skewed the playing field a little bit. One is that it's harder to get an injunction now. Traditionally with a patent, you could stop a company from making a product. And now that's really limited to situations where there are competing products and one product is taking market share from the other. And if you think about it, an injunction is the worst possible outcome in a litigation over a product, because it basically says you cannot make and sell your invention. If you have to pay money, it's one thing, but if you're enjoined, that's another. And that has been scaled back. So that's a positive development. The second development is, and this is something that is an option for defendants in patent troll cases, or in cases where there's real questions about validity, like that dog toy patent that we talked about earlier. The Patent Office has created new procedures that allow defendants or members of the public to challenge facially invalid patents. And they're called inter partes reexamination procedures. I think any lawyer who is brought in to defend a patent case will think about these procedures. They're very expensive. The cost, the filing fee with the Patent Office to file an inter partes reexamination is $10,000. I think it's $12,500 now, I believe. They go up and up and up. And so that's another option to always consider, because if you can short circuit the system and get the patent invalidated, then that's great. If you fail, then you have a patent that's been twice blessed by the Patent Office as being valid. So there are risks and rewards, but it's intended to be a means of attacking invalid patents. And then the final development, this is probably 10, 15 years old also, there are certain patent insurance and quasi-insurance schemes out there. There's a company called RPX in Silicon Valley. There are United Patents is another one, who you can pay essentially it's like an insurance premium. But what they will do is they will attempt to buy patents off the market to prevent them from being asserted against you. And then if you are eventually sued, they offer some payments of your legal fees. It's a little bit like insurance, and they will defend you. I've represented companies that have them. I would say some have had good experiences, some have had bad experiences. And you just have to, unfortunately, it depends on your situation. And they are also not inexpensive. So I think, as a startup, what I would say is that if you're in a field that is highly patent regulated, like if you're going into telecommunications of any kind, hardware or the software, if you're going into chips, if you're going into certain consumer electronics, like if you're going to cell phones, you would really want to think about this kind of thing. But if you're in a truly groundbreaking industry, maybe not. So that's patent trolls. And I'm going to move.
We've got.
Sure, go ahead.
We've got a few questions that have come in. I think probably toss out to you, and you can kind of work them in. I think somebody was asking about how long does an inventor wind up with a monopoly on a generic / utility patent? Like pharma companies typically, I guess, expire in 10 years. And that kind of brought up a bigger question of, could you separate out if there's any key differences or explain the difference between a utility patent and a design patent, and kind of what's the pluses and minuses there?
Yes, that's an excellent question. And so in terms of the term of a patent, it's generally 20 years from the date of filing, but there can be adjustments made. And actually, there are certain older patents. I'm not sure if those have all died yet, but the term was changed, I think, 15 years ago or 20 years ago. So, but in any event, it's roughly 20 years from filing, and there can be term adjustments. The difference between a utility patent, which is what I've been talking about, and a design patent is a design patent really covers a very specific thing. So this stick patent, this would actually make more sense as a design patent, because a design patent just covers like exactly what you see here. It would have to look exactly like this. Probably one of the most famous design patents was an Apple patent on a rounded screen, like, on an iPhone, having a rounded edge. they went through and they have a patent that just covers sort of a rounded edge, and they sued Samsung over having, you know, a rounded edge. And it was just one of the patents that they asserted, but that's what it was. And so I normally, traditionally, I think patent attorneys would have said a design patent, you know, it maybe makes sense for, you know, consumer products where the look and feel is very important, but the scope is pretty narrow. It's really, you know, it has to look exactly like the picture for you to get infringement. Whereas, you know, for a utility patent, it's kind of this, you know, it's this word described claim that covers anything that has these features, regardless of how it looks, right? And this, you know, going back to the dog toy, you know, this can be made out of any material. It can be any color. You know, the protrusions can be any length. And so that's the difference. The other place you see design patents, some pretty valuable design patents, were for iPhone cases. I had a case over iPhone cases, you know, the wallet cases where you put the credit card in. That was a, you know, pretty valuable patent because you know, putting your credit cards in, they just patented every single way of doing that in the design patent. And it's good because all the judge has to do is just look at the picture and look at the product, and like, there you go. There's not a lot of hemming and hawing about that. So that's the difference there. That's a good question. In terms of the costs.
Yeah, I was going to say the other question. Somebody, so you kind of talked about the benefits. Somebody was wondering about, you know, copyrights we get for free and trade secrets we kind of get for free. How much are you looking at if you're, you know, in a garage and you just invented the perfect new thing? What are you looking at from a cost perspective for filing something? How much did they spend to patent the dog stick?
It's a good question. So the filing fees, the filing fees in the patent office, it's a couple $1,000s. I can't remember what $3,000 or $4,000 I think now. You can get small entity status, but it's not, you know, it's not nothing, right? It's not like a copyright, you're right. And so, yeah, that's a good question. So for a design patent, you know, maybe it's like a copyright, but let me jump ahead to actually that question of, you know, a copyright versus a patent. You know, should I get a patent or should I get a copyright? And what a copyright protects is a copy. It has to be like a literal copy of what you made. So, you know, movies. Traditionally, copyrights are books, movies, sound recordings, paintings, photographs, that type of thing, and software. And so, so essentially, the answer is that if you have, you know, software code that can't really be replicated without using that precise code, then a copyright is probably fine. But the reality is most functional things can be replicated with slight differences, right? I mean, you could probably do the code differently. And a lot of times when you hear about open source, you know, open source code means it's not covered by a patent and it's not covered by a copyright. And so the case I talked about at the beginning about the copyright for the APIs, that's a case between Oracle and Google based on the Java APIs. And basically, I think it was Google incorporated wholesale the APIs into a browser. And they argue that that was open source, that it's fair use to use those copies, right? But I have to say that a copyright litigation over software is something of an outlier. It would really be if somebody is just taking the code wholesale and reselling it or incorporating it into something else. Now, that certainly happens, right? I mean, if it takes a lot of time and effort develop a piece of code, I would certainly copyright it. Again, the cost is like nothing. You do have to make it public, but that's sort of the answer. So I guess the question, when would I just go for a copyright as opposed to a patent? I think it would be in that situation, where you have code that could potentially be copied, and you don't want that to be happening. I hope that's an answer. It's close. All right. So let me jump ahead to just sort of an example of a patent, and then we'll move on from patents. But just like an example of what I thought was some clever patenting, right? Where the claim language was very valuable and very clever. And so this was a case I did a long time ago on a medical device. And this is a device, you see the picture, it's an electrosurgical device where you go in minimally invasive arthroscopic surgery into a shoulder or knee, and you have to remove some tissue. So the tissue's down there on the bottom. There's saline solution that fills the joint, and then you apply electricity to sort of take away layers of tissue very carefully. That's the invention. Pretty clever invention. And so, and what you want to do though when you're patenting is you want to be sure that you're covering potential competitors, but not the prior art. Okay? And so in this field of medical devices, it was known to run electrical current through a fluid, through the tissue to remove the tissue. That was sort of known, but it used heat. People weren't quite sure how it was working, and it wasn't very precisely done. And so this company that I represented filed a number of patents, two of which I want to focus on here. The first one shown here, on the left, you have the picture, you have the electrodes, which kind of stick down out of the bottom there into the tissue, which is at the very bottom. And there are these dotted lines that show the electricity flowing through. And then there's the saline solution, which is an electrically conductive liquid, right? And so it's the current is flowing from the positive electrode to a negative electrode that's further up through this fluid. And the first claim that we have here is they basically just talked about, using an electrically conducting fluid so that there's a current flow path through the fluid, which is kind of, that is what's happening, but it's a very basic way of describing what's happening. And then the next claim that they did for the exact same invention, they just went into a little more detail, and they talked about creating vapor over a thin layer, and to induce the energy into the target site in contact with the layer. And, and the difference here is in the prior art, people talked a lot about current just flowing through fluid, but nobody really got down to this sort of creating a vapor, and you can kind of see it in this picture. And the reason I bring this up is this first claim was found invalid over the prior art, and the second claim was held to be valid and was an extremely valuable claim in the patent world. So I raise this just when you're thinking about your patent strategy. One, think about multiple patents with multiple claims approaching the same problem different ways. And then secondly, really try to drill down on what it is you're doing, right? You really want to be as specific as possible. So that's another example of a clever patent claim. Just the last point I wanted to make on patents, and then we'll move on to trademarks quickly, is there's the global aspects of it. So, it's very difficult to sue companies in other countries, especially in China, and a lot of products are made in China. And what we're finding is happening is they're finding ways around that. And so I represent a company, a very large seller of LED lights. And this is the LED chip patent portfolio that I talked about earlier. They were sued for infringing 7 patents related to LED light chips. But my client sold the whole light bulb. So if you look on the left, you see the light bulb disassembled. And then inside there, just over to the right, you'll see sort of a circle with a bunch of little chips on it. Then down below that, you'll see an individual little chip. And the patent claim related to something you could only see with an electron microscope on the chip. And my client had no idea about any of this, right? They didn't buy the chips. They didn't buy the chip assembly. They bought the finished light bulb. And they were sued for infringement because of a chip that was made in China and had nothing to do with them. And I raise this because this is an important global issue with patents, and a lot of products are imported. And what you have to be careful about is, as you're importing products, you want to be sure that your supply chain either indemnifies you or provides you some sort of assurance that what you're getting is not infringing. And sometimes that's hard to get, but as you're thinking about creating a product made of numerous components, you have to think about exposure all through the supply chain on their components, especially in a case like this where the Chinese manufacturer is never going to be sued for infringement, right? Because they're not outside of China, and you can't bring a suit easily in China, but you can in the U.S. So just a word of warning there on patents, and that pretty much wraps up patents. I don't know. Are there any questions that remain, or because if
I think we got through most of the ones. Just thumbnail. What's the whole patent process run like? If I've got some great invention in my garage that I need to file, do you have a ballpark for what a utility patent would run end to end?
Yeah, 5 to 10,000 probably, I would say.
Okay.
Maybe more. Is that what you mean, like dollar wise, time wise?
Yeah, I think they were asking about dollar front, and then somebody was also asking about kind of user interface design be patented, or is it covered by a copyright?
So the answer is yes.
Software user interface. Yeah.
Yeah, right, both. So you could certainly get a copyright for the interface, but again, that would really just protect you from people who use like the exact interface. And then a patent would give you more of how the interface functions, right? And that gives you a little bit more scope. And so I can't think of an example of an interface, although, okay, so an example would be a device for inputting records. Like, let's say you're the example I'm thinking of is like oil field maintenance or offshore oil rig maintenance. They have to keep a lot of records. And so there's a system for inputting the records and then storing the records. That would be a patent, right? And then the actual image that you see on the screen as the inputter, that would be the copyright, is the answer. And I think the patent would probably be more valuable just because you can tweak the interface, make some small aesthetic changes, and get around the copyright.
The other question we got is around a website. And if you've built a product that's a website, could that be both a design and a utility patent potentially? Or would you pursue strictly kind of one or the other?
Again, it could be both, yeah. And I would not limit myself. I would certainly, you would need counsel, and it really depends on what the exact invention is. But I would say, yeah, you could probably do both. Again, my inclination is to go for the utility patent, but as I think it's clear, that tends to be the more expensive route, right? So you kind of have to know that that's what you really want to go down that road. That's the answer.
All right. That wraps up our patent questions for now. I'm sure people will come up with some other things as we move through the next phase.
All right. And then, so now I guess we kind of skipped through some of the polls, but we're to another poll and we're getting to trademarks. This will be the last block that we'll cover. And everybody's sort of seen trademarks. They know about trademarks. And I'll tell people that there's a process where you can go to the US Patent and Trademark Office and register your trademark. And you could just go around, say it's a logo, it's Coca-Cola. You have that. But the question is, before you sue somebody, do you have to have a valid trademark registration? And we'll talk a little bit about some of the symbols that people use, for a registered trademark or non. But I'm curious to get people's initial take on how they would respond to that.
All right, we have about 2/3 of the people voted. If you have different windows or screens, you might look around. We've got a polling window open currently. So circle back around and see if you get the correct Jeopardy question. You don't have to answer in the form of a question, but you can try your luck here.
Prizes are extremely valuable.
Yes, valuable recognition from your peers.
Right.
All right, so I'm going to close this off in 5, 4, 3, 2. Here we go. Ending the poll, and we'll share the results back.
Right. Wow, smart group. That is correct. You do not need to have a registration with the U.S. Patent and Trademark Office to enforce a trademark or to even have trademark rights. That said, there are certain advantages to federal registration, one of which is if you sue somebody, you'd be able to sue in federal court if you have a federal registration. And oftentimes, federal court has certain procedural advantages in filing suit. So good job, everyone. Now, on a trademark, trademarks generally are like logos, right? It's usually logos. It can be color, it could be scent, it could be sound, it could be anything like that. Oftentimes, I oftentimes get questions about the symbols. And so the symbol on the left is, some people will put that on a logo or on some packaging. And that says that we regard this as a trademark. You have notice that we have common law trademark rights. It's not required to have this on there. And then the R symbol shows that you have a federal registration. And some people don't know this. I actually didn't know this initially, but it's actually against the law to put the R on your trademark if you don't have a federal registration. And there's some rule in the trademark office that says if you've done that, you may not be able to get federal registration if you've used this R before. It's not I don't think that, I've never seen that rule enforced, but I know it's on the books. And people always know that. So anyway, so that's what those symbols are. So like I said, you can do color. It's usually logos. It's usually packaging, that kind of thing. This is what a registration looks like. This is for the color. I think it's magenta. This is T-Mobile. T-Mobile uses magenta. They use it on everything. And if you just look at this quickly, it gives the registration number, and then kind of the key part in there is actually class 38, which is telecommunications and information technology services, blah, blah, blah. And trademarks, when you get a trademark for a logo or whatever, it's limited to a specific type of goods, right? So you could use this magenta on coffee cups or cars or computers or whatever. Maybe not computers, but something that's not information technology. And that's really how trademarks are limited. They're really limited to the class of goods. And that's why you'll see sometimes, conflicting marks in the same space. And the classic illustration of that is, Apple Corps was the Beatles record company back in the 70s, and Apple Computer, everybody knows what Apple Computer is. And Steve Jobs really wanted to be Apple. And so he did Apple. And then the English record company came after him and said, hey, look, you can't use Apple. And there was litigation. And the result of it was that Steve Jobs agreed to only use Apple for computers. And that was all fine and good until, and they agreed not to use it for music. And then Apple got into the music business. And eventually they had to pay off Apple Corps. And it's a confidential settlement. But it was probably pretty substantial because the Beatles catalog is very valuable and Apple Music is very valuable as well. But that's one thing to think about when you're thinking about trademarks. So, trademarks, like I said, they can be colors. Again, usually they're logos and product packaging. And the point to remember that's not in the slide is that to get a trademark, it has to be used on a product you're selling. So if you just have, a website with a logo with no products for sale or no services for sale, there's really no trademark there. It's really designed to protect consumers. So when consumers see product packaging, they can be comfortable about the source of origin of the goods. And that's valuable in a lot of cases for a lot of services, right? Because people do rely on that. And for valuable services like Apple or whatever, there's a lot of counterfeiting. And so it is valuable for that. So just in a rubber meets the road kind of analysis, think trademarks if you're selling a consumer product or a widely distributed product that needs to differentiate itself by source, right? So if you're selling sort of like one-off computer solutions to super sophisticated consumers, a trademark probably isn't that necessary. But if you're selling, stuff, like a widely used internet application or something like that, where people buy it and they would recognize your logo, that's when you want a trademark. A couple of points I just want to go back to at the beginning, just to close this out. The trademark, I remember I asked, is the color red on tools a valuable trademark? And for those of you who picked that, you got the wrong answer. And I think it's a little bit surprising, actually, because, red, as you can see, does distinguish things. And this was actually a case related to saw blades. And these pictures are from a decision of the trademark office saying that red is not distinctive among saw blades. But if you look at these pictures, to me, this is totally distinctive, right? These are all different looking saw blades to me. So, so I guess this illustrates that yes, color can be trademarked, but it's color is the trickiest one to trademark. And I'm actually involved in a case right now seeking to get a trademark on a specific shade for a medical device. And it's not as straightforward as it used to be. The trademark office has tightened up a little bit. And it was this case, this red saw blades case, that really changed the tide. This came out a year ago. So color is an excellent way to trademark, especially for consumer goods, but you're going to have to think carefully about it. You're going to have to narrowly define the set of goods, and the color is going to have to be really distinctive if you're going to do it. All right, so that wraps up. I already talked about copyright, so now I just want to end up on litigation, lawyering, and kind of talk about behind the scenes. And I forget what my poll question was. Oh, we have a poll question. I think I'll skip the poll question and just give you the answer. My question was going to be, wrong poll.
Okay. 1 second.
Yeah,
here.
so this would have been the last one. And I can just give you the answer. My question was going to be, what are the estimated attorney's fees to litigate a patent infringement suit alleging damages less than $1 million? And the answer the source of this was from the American Intellectual Property Law Association. They did a survey of their members asking, and they're mostly lawyers and sophisticated consumers of legal services for intellectual property. And they asked them what would be the average attorney's fees, not expert witnesses, not costs, just attorney's fees to litigate a case where the alleged damages are less than $1 million. And they came up with an answer that was surprising. And I'm going to tell you, when we get to the answer, I'm not sure that their answer was right, but it does illustrate something important about this field of law, for sure. All right. So the winner was 500,000, and the answer was actually 700,000. And this is per side. So that means the cost to litigate a case of $1 million in damages would be $1.4 million, split between the two sides, which is just ridiculous. And what it illustrates is that traditionally, this area of law for litigation has been among the most expensive. Probably the only two other more expensive are M&A and highly contested bankruptcies. The average hourly rates are well in excess of $500 an hour for litigation. The litigation goes on forever, and it requires a lot of lawyers. It's extremely time consuming, and it's the yacht racing of litigation. So what I tell people, oftentimes people have, patent litigation questions, and they have, they face issues. And one common issue that people face is they'll get a letter from somebody saying, you're violating our patent, pay us money or we're going to sue you. And not very many companies are in, not very many startups at least, are in a position to respond to that without consulting a lawyer. And a lot of mid-sized businesses aren't either. And so, I certainly represent a lot of companies that have internal legal departments and have their own ways of dealing with this. But I also represent, smaller companies and mid-sized companies. And, it always shocks me. Sometimes I'll have a client and they'll have talked to a number of different law firms, and it always shocks me the differences in rates and the differences in approach. And to be perfectly honest with you, you should shop around for a lawyer and find somebody who can put together for you a package of fees that looks at the matter in stages, right? So instead of saying, you're in big trouble, this is going to cost you millions, you really need somebody to say, look, this is what I forecast the costs are going to be. We're going to deal with this letter. It's not going to cost very much to deal with the letter. But if this doesn't work, then this is the next step, this is the next step, this is the next step. And these are the off-ramps, right? These are your settlement opportunities. And so what I would say, circling back to the response to a violation notice, I would contact a lawyer, but my inclination would be to not overdo it in that situation. I mean, take it seriously, examine it, but work with your lawyer to find a commercially reasonable response that indicates you're taking it seriously, but you don't find infringement and there's no need for litigation. I think there are companies, I'll tell you right now that there are companies that get notices of violation and they just throw them away. I know large companies that they only respond to lawsuits. And that's probably not the best way to do it. But again, I think, you're probably looking at $5,000 to $10,000 to talk to somebody who's, decent at this, maybe more. and to just sort of sort out what your exposure is on any given violation notice. The other option, the other thing I hear people talk about doing is a freedom to operate opinion, where you hire a lawyer to look at the field of patents out there and say, is what we're planning on doing, is there going to be any problems there? And those make sense in certain fields. I think it makes sense in pharmaceuticals. It makes sense if you're in a crowded field like medical devices or something like that. But in fields where, like software, where there are just so many patents out there, sometimes it's just not practical. So I generally would discourage that as standard operating procedure, unless you're in an industry that's sort of riven with patents. And I guess I would say you would know if you need to do that based on your industry. And then finally on costs, like I said, this illustration I have here, I guess I should explain this, it's from a Dickens novel, and it's about a litigation over a will. And the whole joke is that this guy here who's sitting consulting a lawyer, he thinks he's going to get rich fighting this will. And so he's hired this lawyer, and he's spending all this money to have this lawyer contest the will and fight to the very end. And 3/4 of the way through the book, he's standing outside the court waiting for his lawyer to report to him. And he sees all the lawyers walking out, and they all look really happy. And he says, "What happened?" And he says, "What happened?" And the lawyers say, "Oh, it's over." He's like, "Oh, did I win?" No, you didn't win. We spent all the money in the will on legal fees, right? And that's, the thing to avoid, right? And it happened in Dickens's time, and it's something to avoid here. Really, to be fee conscious, I think, is extremely important for any litigation. And the advice I always give people is to take it in stages and get a solid budget, per stage. And that is, what I have. I don't know if there's any more questions. I went a little longer than I thought I was going to, but I'll take any questions.
Yeah, this has been fantastic. If people have questions, feel free to put them into the chat window. We can spend a little bit of time getting some questions in. I could launch the last poll that we skipped, just as a amusing point while we're waiting for folks to chime in with any questions that they've got. And the poll was, which of the following is still protected by copyright? The song Happy Birthday, George Gershwin's Rhapsody in Blue, Agatha Christie's, and I'm going to butcher it, Poirot Investigates. I always have trouble with that one. Or Buster Keaton's movie Sherlock Jr. So we'll give people a little bit of time with that question. Wondering if anybody has any remaining questions kind of around patents or copyrights or trade secrets or any of these things. Dean is asking if he has a domain that is the same as a trademark, like something.com or something.io or dot whatever, and that's being used as a website address. If that happens to coincide with somebody's trademark, like somebody else grabbed and trademarked something.com, are you potentially in trouble from a trademark violation standpoint, just because you're using a domain that happens to have, use one of the words that they've got in a trademark?
Right. So again, it depends. But generally, so one point to make is that trademarks are first come, first served. So if you were using it first, you don't have a problem. And then if somebody is using,
What if
I'm sorry?
I was going to say, what if you've had the domain since like 1990 or something, and somebody, product.com, and then somebody just came out with a product using, product as a name, and they've gone ahead and trademarked that, but you've had the domain longer than they've had the trademark.
I see. And if you're selling products, if you're using product.com to sell products and they're using product.com to sell products, then that would potentially be a trademark infringement. That would be potentially confusing to consumers. And that's the kind of confusion that the Trademark Act is intended to avoid.
Okay, so if you're, it's really kind of it sounds like the deciding factor is this potentially causing confusion to consumers if they're selling candy bars and your website's all about automobiles, that you might still have some leeway there.
Right, exactly. If it's a different class of goods. And I guess I should also say,
Okay.
Yeah. Again, all these things depend. And so, obviously there's no attorney-client relationship here on any of these. You'd have to, seek your own lawyer. But generally speaking, I think that's the answer.
Oops. All right. Any other questions from folks? I've got, we will end the poll on the copyright and share the results out to folks. Most people here voted, 42% picked happy birthday. We have about 20% on Agatha Christie or George Gershwin, and we have a couple of people that were going for Buster Keaton.
Right. So again, good job on the group. The song Happy Birthday, it actually was copyrighted until 2015. But the song originally was written in the 1800s. And the reason why I had this in there is just to illustrate that it is extremely difficult to calculate a copyright term. Traditionally, it was the life of the author plus 70 years, and a different thing for corporations. The upshot is copyrights are long. They're like the longest one. So I just had this in there to illustrate that point. And then, these other three, basically these things went into the public domain based on a law Congress passed a few years ago that just changed the copyright code. So copyrights, again, this was just intended to illustrate that finding out the term of a copyright is extremely difficult, but for practical purposes, it's fair to say it's long. And that was all that was intended to illustrate.
Excellent. Sorry, we just got another question in from Nikhil. If he has a patent, if a patent is not approved, so they're producing a product, they filed a patent on it, and the patent office kicked it back saying, "Nice try, but we're not going to grant a patent." Does it then stop production of your product, or where does that leave you from a product standpoint?
Yeah, so again, it depends, but you can certainly continue to make a product without a patent. The concern would be, I think, twofold. One, if the patent was denied because there's another patent out there that covers what you were trying to claim, you might be worried that you're infringing that other patent. In other words, the reason why your patent was denied might be another patent that you're potentially infringing. Again, that's just possible. I mean, possible it's not. There's a number of reasons patents are denied. And then, the other thing, it's rare that a patent is just outright denied. You can usually narrow the claims or work the claims in prosecution, in front of the patent office, so that you at least get something. There's usually a way to tweak the claims, unless what you're doing is just so obvious that it won't get through. But again, that stick got through, right? So, there's probably a way.
Then one final question that came in. If you have a product that's on the internet and you've gotten U.S. protection to intellectual property, But knowing that there's differences, say, in copyright terms and also patents, the way they work country to country. I offer a global product from the US that has a US patent. Somebody in, say, Germany gets an EU patent to offer pretty much the exact same service, but they're protected by an EU patent, and they offer it globally via their website. Or maybe the UK is a better example if it's an English website and an English website. How does that resolve itself when you've got like competing companies doing the exact same thing, but it's in a global marketplace like the internet, and they each have got protection within their jurisdiction, but you're providing the product on a global basis to the internet? What does that look like? It seems messy.
Yeah, right. So what, like that should not happen. Actually, there should not be a situation where two people anywhere have a patent with coextensive scope. One person should be given priority for that patent. And I guess I'm surprised I've never heard of that sort of hypothetical, because it could happen, because like Europe is traditionally a first to file system. Ours traditionally was a first to invent system. So I guess theoretically you could have two valid patents with the same scope. But so I guess theoretically your products would infringe in Europe, their products would infringe in the United States, and I guess whoever else could get coverage around the world would have an opportunity to get coverage over there. I can tell you what would happen if there were two coextensive claims in the United States. There would be a proceeding in the patent office to determine who gets the patent, because the patent office, it's called an interference, and they would never allow two patents with coextensive scope to issue. But I guess I'm not sure exactly. It'd be a mess for sure. I don't know, legal fees.
It's a great idea for some sort of dramatic script for somebody to write, I suppose.
Yeah.
Probably not as exciting as most legal television or novels. But with that, I'd like to thank everybody for coming this evening, and especially our speaker for providing such an interesting topic. I think this has been something that's been very valuable. I've certainly learned a few little wrinkles that I didn't know before this evening, and hopefully you've all got something out of it as well. If you have coworkers who are doing something more important this evening, or didn't find out about this before this evening, feel free to send them to our YouTube channel. We will have this presentation posted by next week at the latest, but most likely much sooner than that. I'd also encourage you to look through the sbpna.org website. We've got almost 20 years of archives on all sorts of product management topics. And I think there's even 3 older presentations on intellectual property over the last 20 years. It's evolved quite a bit since then. You can research all sorts of things and share knowledge back and forth. So with that, again, stay tuned. Next month we have a couple of speakers lined up. I'm not certain which one is going in January and which one is going in February, but we look forward to seeing all of you back in a more cheerful 2021, hopefully from the year's perspective. And stay tuned to the website. We'll be announcing the speakers for January and February very soon. And again, thanks for coming. We'll see you next month. Please stay safe through the holidays, and enjoy a little bit of time, hopefully you get, and we'll see everybody in 2021 in a bright, shiny, happier new year. Thanks everyone, and we'll see you next month.
Thank you.
Thank you.
Thank you, Perry.
Thank you.